business.
Okay.
And we are live. Hello, Michael.
Hi, how are you?
I'm great. I want to introduce everyone to my illustrious nephew, the estate planning attorney, the managing partner of Wild Felice and Partners, and the well-known philanthropist in Broward County. Michael, how are you doing today?
Well, I'm doing great. It's a couple days before New Year's, and it's just a very enjoyable time.
Excellent. I'm glad to hear it. I'll ask you personal questions about the family when we're not doing a hangout.
Okay.
But right now, I want to ask you some questions related to your business. The most salient question that I have for you is, what is estate planning?
Well, it's funny, everyone has a misconception or their own idea about what estate planning is. Even at one time I was at the grocery store and a person thought I said estate planning, that for the state of Florida. And it's no, estate planning is really what happens to your stuff, when you die, what happens to you while you're alive, what happens to your kids if something should happen to you, things like that. And people oftentimes, they'll hear estate planning thinking like, well, that's for rich people. I don't have an estate. What do I have? I have a bunch of garbage in a house that the bank still owns and I'm paying for. But an estate, everyone has an estate. If you have $1, you have an estate. If you have a beneficiary, you have an estate. The key is to make sure that that estate is managed the way you want. And that's where the planning comes in. So while everyone tends to focus on the word estate, the word planning is much more important. Planning, getting it done, getting paperwork done, getting the funding, getting the beneficiary designations, getting all of that in place prior to your own death or incapacity, because unfortunately, it's very difficult to plan once you have died. So it's important to get all that done ahead of time and make sure that we don't really worry about that word estate as much, but make sure we worry about that word planning and what do you want to happen to you, to your children, to your stuff if something should happen to you.
Okay, I understand, but here's where I'm really confused. People talk about having a will. What's the difference between setting up a will and a trust?
Sure, that's a great question. In fact, it's a very common question that we deal with. Most people, when they call up and they don't have any background in estate planning, which is most people, they'll call up and say, I need a will. And some attorneys are, we call them just drafters. They're like the monkeys with the symbols that you walk in and you say, I need a will, and they say, okay, what's your name? That's not how we do things here. We're very holistic, and we always ask why. Why do you think you need a will? Most of the time, the reason they think they need a will won't accomplish the goal. So people will come in and say, I need a will to avoid probate, which, we'll talk a little bit more about probate in a second, but probate is just basically the transfer of assets after you die through the court system. They want to avoid that, but all wills have to go through probate. In fact, the definition of probate is the proving of the will. So we don't want to go through probate, so therefore we can't use a will, we have to use a trust. A trust is a document that is active while you're alive. A will doesn't become active until after you die. It's testamentary. So with a will, you're talking about just directing assets, but through the court system. A will does do two important things. A will appoints an executor, which you need to do. And a will also, if you have minor children, appoints a guardian for those minor children. But other than that, it doesn't do anything to really help you with the assets, with the avoiding of probate. So what a trust does, a trust is like setting up a company or what I always use the analogy of a safe. We set up a safe and we put the assets in the safe. While you're alive, you control it. You have the combination. You can go in and take stuff out. You can put more stuff in. There's no limitation to the grantor, to the person who sets up the trust. But when that person dies, the trust acts like a safe and protects the assets inside, protects the assets from creditors, litigation, bankruptcy, divorce of beneficiaries, anything that might happen to those beneficiaries, protects the assets from creditors of the estate. So a person dies owing money to a credit card company. The credit card sues the estate for the money, but the money that the assets that the person had are not in the estate, they're in the trust. So the trust acts like a shelter. Now, the other thing the trust can do is limit what the beneficiary can do with the money. So allow for the person who sets up the trust to control assets long after they're gone. In fact, in Florida, a trust can last up to 360 years. Most of my clients, even the richest ones, don't have assets that will last 360 years. But what it can do is it can make sure that if you have a child that's young or irresponsible, that they can't access the money until they're either old enough or have achieved something such as graduated college or done something. I've had clients that have restricted trust distributions based on income, W-2 income, so they want their kids to have a job. They don't want them to live off of the trust funds, things like that. The most common restriction being age, like I myself, having your grandniece and nephew of 7 years old and 2 years old, they can't manage their money right away should I die. So 30 is the age that I chose for them, and that's how I've restricted them. If one of them upsets me later on in life, I might restrict it even further. But as for now, I'm able to control those assets. So should I die today with a 7-year-old and a 2-year-old, until the age of 30, they have to ask the trustee for permission to use the money. So the trust avoids probate. The trust allows asset protection for the beneficiaries. The trust allows control after death. And the trust also can reduce or eliminate estate tax if a client is concerned with estate tax, because the trust will allow for not just the reduction of estate tax liability for the grantor when they die, but also it will make sure that if the children die with a large enough estate, that any of their inheritance is not going to go to the government. Their inheritance will stay in trust and go then to the grandchildren or charity or friends or whatever the grantor has decided happens after that beneficiary dies. So a trust allows for a number of benefits, whereas a will doesn't do any of those things.
Well, will a trust automatically protect the estate from creditors?
A trust can. A trust can, yes. I mean, depending on how it's set up and how it's funded, because one of the most important things about a trust is that, like I said, it's fireproof, waterproof, burglar-proof safe, and we drill a hole in the bedroom closet floor and we cover it with a blanket, but we leave all the assets out on the dresser. It doesn't really do much. So we want to make sure that all the funding occurs while the person's alive. We don't wait till after death. We make sure that the house is put in the trust, that the bank account, that the brokerage account, all the things we're trying to protect are put in the trust. As long as that happens, then yes, when the person dies, the trust avoids the court system, it avoids the creditors, and what ends up happening is the trust gets its own tax ID number, it becomes irrevocable at that time, and it's completely protected.
Ah, excellent, excellent. Well, how much money would I need to have to plan an estate, to get an estate plan going?
Well, it depends on my bill, but beyond that, I always tell people the magic number is $75,000 that you should think about. And that's not how much we charge, obviously, I wish. And I'd have a much more dynamic high-def camera in office. But what I would say, 75,000 is that magic number, because that's when probate, full probate kicks in. So probate is, like I mentioned, the process of transferring assets from the deceased to the beneficiaries. A full probate administration, which is amounting to assets over $75,000 in aggregate, that requires pretty much at least 6 months, because we need to do a 90-day creditor period. We need to have an executor appointed. We need to get a letter of administration. There's a lot of things that happen. So usually it runs between 6 and 18 months. And that's if there are no contests or litigation. So as long as all the beneficiaries are playing nice, it's usually between 6 and 18 months. Usually costs between 7 and 10% of the estate assets, considering lawyer fees, taxes, court fees, creditors, things like that. So figure that we lose that much money dealing with probate. So we want to avoid that. We want to make sure that we avoid the probate process. If we do have to probate, it's important to probate as quickly as possible, though. To save all that money, to save that time, to save that aggravation, we recommend putting everything in that revocable trust to avoid the probate process altogether.
Okay, you've mentioned probate quite a bit here. Can you define the word probate?
Sure,
simply?
and that's simply just grabbing all the assets you have in your name at the time of your death and giving them to the court to kind of wash, almost like how the mafia used to launder money. This is the legal way of laundering the money. It cleans the money, cleans all the assets by making sure that all creditors are paid in the way that everyone gets paid. Taxes get paid first, then comes the court, then comes the attorneys. Well, we wrote the law, so of course. Then the funeral home, we have to make sure the funeral home gets paid, you know, because we don't want bodies stacked in the street. We want them to know that they're getting paid for burying people. And then the creditors of the estate, all the creditors get paid. So if there's any creditor, hospital bills, credit card bills, mortgage payments, whatever it might be, we can't do anything about that because they can put in their claim during the creditor period, and then we can either dispute the claim or we can pay the claim. But you know, they get to put their claim in and delay it even further. And then, you know, after that, whatever's left over goes to the beneficiaries. So simply, probate is giving away a lot of your money and then making sure the rest gets to the beneficiaries you've designated in your will. And it's all up to the judge to decide that. A judge will authenticate a will. So a judge might look at the will and feel like it was not legitimate. It was done under duress. You know, oftentimes we have people that have you know, non-conventional distributions through their will, and if it's contested and a judge gets to rule and says, you know, I don't feel like any normal person would make this type of distribution, they might undermine the will. We want to keep it away from the judges. We want to keep it away from the court. We want to keep it away from any contesting beneficiaries. We want to make sure it's clean. So you know, we want to avoid the probate process. Now, you know, I make a lot more money on probate than estate planning. So anybody out there who knows someone who died with only a will and not a trust, please send them my way. But I like for my clients to avoid probate and just do trust administration. It's much cleaner, much faster. Heck, we've administered trusts. It's taken 2 weeks. You know, sometimes it takes a little longer, but you know, it's quick, and as long as everyone plays nice, it's usually pretty cheap.
Cool. Well, as you can see, as the audience can see, I have a white beard. It's not because I'm old, it's just because I have a child and it ages my appearance. But my question is, how old would I need to be, or anyone, to start worrying about estate planning?
That's another common question I get. So, you know, about the money, a lot of people think I need $1 million. It's only 75,000. When they ask me about age and they say, well, how old do I have to be to worry about it? I say, well, that depends. When are you going to die? Because if you know when you're going to die, I say we plan like just a couple weeks before that, because you could wait until then. And in fact, that week buy life insurance too. It's a smart thing to do at that point. But because we don't know when we're going to die, it's important to plan as soon as possible. And, you know, instead of worrying about age and assets, I always say worry about beneficiaries. Because if you're 90 years old and you have $9 billion, but you have no family, no friends, no charitable intent, what do you care if the government takes half your money? Honestly, where's the other half going? You don't even care where it goes. So, but if you're, you know, 36 and have a 7-year-old and a 2-year-old, estate planning is crucial, no matter how much money you have, no matter how old you are. In fact, I've had clients, you know, that have died in their 30s, and I've had clients that are still alive at 100. So you just never know what's going to happen. In fact, the worst piece of advice I ever heard given by another estate planning attorney was, I spoke to a woman who she had a 2-year-old daughter. She was divorced and she only had a will. And I told her, I said, listen, you have a successful business. You have a 2-year-old daughter. You don't want your ex-husband getting anything. Set up a trust. She went back to her estate planning attorney who had set up the will. And his advice to her is, we'll worry about this in 10 years. 34-year-olds don't die. And I thought that was the biggest piece of malpractice I ever heard. Unfortunately, she didn't listen to me. She listened to him, probably because she didn't want to spend money on a trust. But hopefully she's still alive, because I think she's got a few more years left till she turns 40, and then he'll maybe talk to her about a trust. But for those people who are mortal, which I might remind everyone, the death rate in Florida has held steady at 100% for quite some time. I recommend getting an estate plan done as quickly as possible.
Excellent. Well, let me ask you a kind of an indelicate question. How much does it cost?
Well, the great thing is that our firm does not charge hourly. A lot of people worry about calling an attorney, sitting down for a consultation, going over the assets and having multiple meetings or phone calls, because they're worried every time they're talking to the attorney, the bill goes up. We charge a fixed fee. We always do free consultations as well. So when a client calls me up and says, well, how much does it cost? The only thing I can guarantee them is The consultation is 100% free, and we will quote a fixed fee at the end of the consultation. So at the end of the consultation, I quote the fee. The client gives me the thumbs up or the thumbs down, or maybe they try to negotiate a little bit, but we have a fee. And at that point, the fee never goes up. So some clients, they'll require just 2 more meetings and that's it. Some clients require 6 more meetings. Either way, the fee is the fee. It's totally fixed. Now, clients will say, well, can you give me a range? And that I can do, just because I know what most of my clients need. If you're a married couple and you want a trust-based estate plan, you're looking at somewhere in the neighborhood of $3,500. And when we talk about a trust-based estate plan, we're talking about the trusts that we talked about that give asset protection, creditor protection, control, all of those things, avoid probate, the whole kit and caboodle. And it also includes the assignment of property to trust, which funds the trust with personal property like watches, jewelry, collectibles, furnishings, things like that. The pour over will, which could appoint a guardian for a minor child and an executor for the estate, also points to the trust for any assets that were left out. A durable power of attorney for making those financial decisions if a person becomes incapacitated. Designation of healthcare surrogate for medical decisions. A HIPAA release to see medical records, and a living will, that advance directive, that pull the plug document. So it's 14 documents that a married couple will receive for, usually around $3,500, depending on, what they need. Some clients a little bit less, some clients a little bit more. For a single person, it's probably going to be in that $2,500 range. And again, some clients need a little bit less as far as the documents are concerned. Some clients need a little bit more, but that's on average, an individual pays about $2,500 for 7 documents. Married couple pays about $3,500 for 14 documents.
Oh, that's quite reasonable, quite affordable. I'm really surprised. But I do have a question. With all the internet things available, all the self-help things online, why can't I just do my own estate planning?
Well, and that if you are an expert in estate planning, if you're a trained estate planning attorney, then you can. But for those that aren't, we don't recommend it. Just like we don't recommend operating on your own heart, or even honestly, in most situations, doing your own taxes. You could just paying a professional. You save so much money, so much time. I have reviewed many estate planning documents of people that tried to do it themselves. The people that are alive and have me review their documents, I am able to fix them. The people that have died and I review their documents doing it themselves, unfortunately, it becomes a mess. Just a couple examples. I have one client who she did her own will. We're doing a probate now. The problem is it was a pour over will. She filled out a pour over will. Well, a pour over will, as I explained, points to a trust, but she didn't have a trust. So it pointed to a non-existent trust, which meant that there were no beneficiaries, and we have to go through a complete probate with no beneficiaries. There's no way to tell who they are, and we have to go to the statutes, Florida statutes, and decide who does the court think the beneficiary should be. That's not ideal. Then another person, she did her own will on LegalZoom. She printed it out, she filled it out. She filled out, first of all, her ex-daughter-in-law as the personal representative, who was her current daughter-in-law at the time she filled it out, but never updated it. And then that daughter-in-law brought it to me, and it said, it was a blank, so I'll fill in the blank, says, I leave blank, and it lists assets. So she lists her house and her IRA or her 401k and all these things. She makes a whole list of assets, and then it says to, and it's blank. Again, no beneficiaries. So how do we go about it? If you the whole idea that these are form documents, that these are plug and play, is the biggest misnomer in estate planning. Because it's transactional, people think they can do it themselves. If it was litigation, they would never try to do it themselves. Because it's transactional, they feel like they can do it themselves and save a few $1,000s. Well, if they do it wrong, it could cost tens of thousands of dollars in fees, not including any litigation fees that we have to. I mean, I've seen some that have gone into litigation and cost hundreds of thousands of dollars. So we want to avoid that. I always say that if you do your own taxes and you mess that up, the IRS gives you 3 years after you file to amend that tax return. If you do your own estate plan and you screw that up and you die, you don't have any time to go back and amend. So get it right the first time. It's a one-time fee. It's a fixed fee. We don't nickel and dime. We don't charge hourly. It's just really important to get an estate planning attorney that you trust, that can explain things to you, that can work you through the process, and just get it done, and you'll know it's done right.
Excellent. Well, listen, aside from picking up any newspaper in Broward County and reading about all your philanthropic endeavors, how can someone get in touch with you?
Well, that's a great question. So there are many different ways, especially in this multimedia world, to get in touch with me. One way is the old-fashioned way by telephone. Telephone number here at the office is area code 954-944-2855. They can contact me by email, which is M as in Michael, W-I-L-D, so mwild, at WFPlaw.com, or visit the website at www.wfplaw.com, or get me on Facebook, get me on LinkedIn, get me on Twitter, whatever it is, Google Hangouts, right? YouTube. There's plenty of ways. My Twitter handle is Florida Law Firm, or at Florida Law Firm. My on Facebook, you can find us at Wild Felice and Partners PA, or contact me directly, Michael D. Wild. No E in Wild.
That's right. Our ancestors couldn't afford that extra letter.
Exactly.
Anyway, Michael, this has been a real pleasure and very edifying. I'd like to thank you very much.
My pleasure. Thanks for having me.
Sure. Let's do this again soon. I'm sure I'll come up with a whole bunch more questions that my audience will love to hear the answers to.
Sounds great.
Meanwhile, you have yourself a really happy New Year.
You too. And hope to see you soon.
Speak to you soon.
All right. Bye.